As we get more and more people to come in, I just want to, for those of you who haven't met me yet, I am Shelly Grenagher. I'm your Director of Alumni Relations here at South Dakota Mines CARA, the Center for Alumni Relations and Advancement. Before we start, just a few housekeeping items. We are recording today's Zoom and it will be uploaded to our CARA YouTube channel, but this does take us a couple days, so please be patient with us. I want to encourage you to use the chat function and say hi to everyone. Let them know that you're here, your major and your graduation year. To use this function, you're going to click on that word bubble at the bottom of your screen. A chat window will pop up. Please switch your responses to all attendees and just let us know who you are here. If you do have a question today for our presenter, both Bobbi or Leah, please put those in our question and answer bubbles that says Q&A down there. And at the end of the presentation, Leah will give a chance for her and Bobbi to answer those questions for you. I'm going to go ahead and start off our chat today with my email. So if you do have any questions, if you have any, like I said, alumni events or anything like that you want to do, or you have a topic you want to hear about from campus, please respond and let me know what you're thinking. And with that, I would like to introduce Leah Mahoney. She is a 1980 geological engineering grad, and she's currently the Director of Plan Giving at CARA, and she's been with us for about 26 years, so she is an absolute pro. So with that, I turn it over to you, Leah.
Good morning, everybody. I'm happy to be able to talk about our speaker for this webinar, who is Bobbi Thury. She did a webinar for us a year ago, and it was very well received with lots of alum attending and sharing that video with their family and friends. So we're happy that she's back with us today. Bobbi is an alum of South Dakota Mines, and she graduated in 2003 with a degree in interdisciplinary sciences. From there, she went on to the University of South Dakota Beacom School of Business, and she earned her Master of Business Administration degree there. In 2007, she graduated from the University of South Dakota School of Law, and then following law school, she clerked for the South Dakota Second Judicial Circuit and then became a partner at Cutler Law Firm. In 2016, she co-founded Legacy Law Firm, which specializes in estate planning, elder law, and business planning. Bobbi holds her bar admissions for South Dakota, Minnesota, Iowa, and the United States District Court for the District of South Dakota. She's won numerous awards throughout her career, including State Bar of South Dakota Lawyer of the Year and Great Plains Super Lawyers Rising Star. She's very active in professional national organizations as well as local ones. She is active in her community and has served on numerous boards in leadership positions. And somehow her and her husband, Chad, find time to spend with their 4 children. And she also volunteers to give presentations like this one for us. So without further ado, I would like to introduce you to Bobbi Thury and her presentation, The 7 Estate Planning Mistakes That You Should Avoid.
Thanks, Leah. Appreciate that. And thanks, Shelly, as well. I'm going to go ahead here and try to share my screen. So bear with me here. All right. So today we're going to be visiting about the top 7 estate planning mistakes that we commonly see happen in our area. So the very first one to get started is dying intestate. And that's probably something that we see happen with regular basis. And it's pretty common. The statistics range anywhere from that 30% to 50% of Americans have a will or estate plan in place, which means the vast majority to super majority of Americans, right, don't have anything in place. The thing that's important for you guys to know is that if you don't set your own estate plan, the government sets one for you. And this is what we call intestacy or intestacy laws. So if you don't want the government basically to dictate how things will run, it's very important to make sure that you are setting that up for yourself and for your loved ones so that you don't have to go to the default rules, which is the government rules. Now, a lot of times people might think, hey, if I don't have anything in place, the government gets it. That's not true. It's just that the government says who gets it and how they get it. And potentially, if there's not known errors, right, then it could default to the government, but that's very rare. But what you're doing is you're leaving essentially what you have worked so hard for over your lifetime and the people you love at risk and giving them more heartbreak and heartache by the extra work, costs, expenses, and what we are most fearful of in my industry is potentially not having your wishes followed because the government's rules are being followed. So some things that you can do to make sure that you don't have any loose ends. So first of all, make sure you have designations on things. So retirement accounts, right? Life insurance, all of those types of assets that you can have a beneficiary designation on, make sure you have a beneficiary designation on it. Bank accounts can have payable on death designations. A lot of people don't realize that you can have a designation on a checking account. You absolutely can. Those are called payable on death designations. And then you can also have transfer on death designations. So like an investment account can have a transfer on death designation. Also, if you own like an LLC or a corporation, maybe you have a side hustle or a family cabin that you have protected in an LLC, those can actually have transfer on death designations on the certificate as well. If you have a beneficiary designation, payable on death designation, transfer on death designation, then at time of death, by operation of law, right? That's a contract that they have to follow. It has to go to the person that you designated. So this way, the state laws, right, your intestacy laws won't control. Instead, that contract, that designation will control who gets it at the end of the day. What some people don't realize, though, is that you have to be careful and diligent when you're updating beneficiary designations, because if, say you have children on there and one of them passes away, right, what happens then? So a lot of times people under an estate plan will say, if I have a child pass away, I want to make sure it goes down to my grandchildren. And so you build in those provisions. But if you only have a beneficiary designation that says to my children and a child passes away, make sure that you're getting in there and updating that beneficiary. Or here's another pro tip that you can use. Add the words per stirpes behind. So that per stirpes is Latin, basically saying that if that person named does not survive, then it automatically goes down to the next generation of that child. So the grandchildren, right? The child's children. So that way you've automatically got that built in, and then you don't have to worry about updating it. Now, there are going to be assets that you have that don't have the capability just to simply add a beneficiary designation. So some alternative options for other assets that don't have those designation capabilities. If you have assets held with joint tenants with right of survivorship, again, by operation of law, it's going to transfer to that surviving owner. The question becomes, though, say that surviving owner is with you in a car accident and the two of you perish together. So spouses perish together. Well, then there is no surviving owner, right? So then that can potentially place the family or loved ones at risk of not having intentions followed. So, but joint tenants with right of survivorship, whether it's a joint account or a home that's owned with joint tenants with right of survivorship, by operation of law, it will go to the surviving owner. Now, here's something you can check on. Sometimes people don't know, are they tenants in common on a home deed? Are they joint tenants with right of survivorship? You know, it's really important that you know how you own assets, because that's going to dictate how things go and also your rights. So I would recommend, if you don't know how it's named on the deed for your home or titled on any other asset, figure it out now. The other option that you have in a number of states, so not every state has this, but a lot of states now have transfer on death deeds. So this essentially is a separate deed that you can file with the Register of Deeds in the county that you're at. And it is basically a beneficiary designation that says, hey, if I don't survive and there's no surviving joint owner, then these are the individuals named or entity named that it would pass to. And having that transfer on death deed avoids probate then. And it says, here's who I want it to go to. So again, those intestacy laws that the government has for you can be avoided. Now, transfer on death deeds usually have to be recorded. I don't know of an exception to that. They have to be recorded prior to dying. So this is something that you need to make sure that you would get done ahead of time. And the other thing to know about transfer on death deeds or any beneficiary designation is that sometimes it just isn't ideal for the family, because sometimes children don't get along, or sometimes you have maybe not children on there, but other beneficiaries. Maybe it's a charity, maybe it's siblings. If you have a number of different people, for instance, say you pass away and you have a home and it's going to, siblings and a charity is who you want to go to. Well, they're going to have to agree. They're going to have to sign off on documents. They're going to have to handle the closing. So sometimes it's actually better not to do just a designation or a transfer on death deed, because you can get in those situations where the beneficiaries don't agree and they have to all act, and then it becomes an administrative burden. But if you can keep it simple, these are great simple options, is to have those designations and a transfer on death deed. Another option would to be having a trust in place. So if you have a revocable living trust or an irrevocable trust, you can move assets into that trust. Because the trust is the owner of it, and the trust is an entity, the trust never dies. And so then you avoid probate, right? But then you also get to designate who gets it when you're gone. So you can say under the trust, I get it during my life, I'm my own beneficiary or my spouse. But then when I pass on, then under the trust, you say who gets it. And you can build in a lot of other provisions that you can't with simply a beneficiary designation. So for instance, say you have a child with special needs, or say you have children who can't get along, or maybe you have a child who doesn't manage money well, or you have siblings who, don't want to do the work, but maybe one of them is willing to do the work. So all of these options are great, especially to have a trust, because you can't build out those ease of administration and protective provisions under a simple beneficiary designation. And then, of course, the wills, the last will and testament. So with a will, that is going to be your death instructions, so that people know who gets what and who is going to be serving as the personal representative or executor, so that you've left those instructions for people to follow. And because you've left those instructions, intestacy laws do not kick in. You do not need to fall back on those government laws, because you have said who gets what, how, and when. So mistake number 2 is relying on that I love you will. So it sounds wonderful, right? I love you wills. So basically saying that, hey, if I'm gone, it's going to this person. So it's commonly, right, maybe a spouse, or if no spouse, maybe children. So the I love you wills are important. Don't get me wrong. Wills are very important to have. But a lot of times we see the wills just not working like people want them to, because they do have certain limitations. They are just death documents at the end of the day. So they do nothing for you during your lifetime, and then they just give the instructions. So some things to know about wills. So concerns is, a lot of times people think they have a last will and testament, that they avoid probate. That is incorrect. If you have a will, I want you to think of this. I want you to think of the will as the ticket to probate. The will is what gets filed at the courthouse, and the will gets probated. So what is probate? So probate's just a word for the legal process of being able to administer assets and distribute assets after a person passes away. So if you pass away and you did not have, right, the beneficiary designations, the joint tenants with right of survivorship. So say you had a home and a checking account in your name and you got hit by a bus. So what happens is, because you are no longer alive, you can't write out a check, right, to pay your last tax return, to pay final expenses, a funeral plan, because you're no longer alive. The owner has died, so that bank account freezes. Same way with your home. If you wanted the home to pass on to someone, no one can legally stand in your shoes to write your name on, the closing title work, to transfer that to the next purchaser or owner, right? So something needs to happen in order for someone to step in your shoes because you're not there. That's the probate process. It is the legal process of having someone to be able to step into your shoes to administer assets that were in your sole name at time of death. So each state's going to have their own probate thresholds and laws. So for example, here in South Dakota, you can have up to $100,000 in total assets. If you have less than that, it's going to be considered a small estate and you don't have to go through that probate process. If it is 100,000 or more, and that's collective. So say you have a checking account, a vehicle, a home, right? And that's more than 100,000 in your name at time of death that didn't transfer by designation, then that has to go through probate. So in South Dakota, we also have a real estate cap. So if your real estate is 50,000 or less, you can avoid the probate process. If real estate is 50,000 or more, again, that throws you right into that probate process. So know what your state laws are, and then just try to make sure that you're being smart with avoiding probate. At the end of the day, there's just no need to have those extra expenses and that extra work on loved ones because it can be easily avoided. So that's something to know, what your state laws are, and then avoid it. So, but if you do a will, just know that doesn't get you out of probate. That's your ticket to probate. The will is what gets probated. A lot of times people don't realize that it's more work for the spouse. So the spouse usually has to be the one, even if there's a joint bank account, because they're a joint surviving owner, they still have to take the death certificate there and get the decedent, the spouse that passed away, their name off the account, update all asset holdings. And then if they're going through that probate process, then there's even more legal hoops for them to jump through. And I would say almost all of my clients that I meet with, one of their goals is to make it as easy as possible for the spouse and the family. And so a lot of times that I love you will isn't accomplishing that goal, but yet people think because it's a will, it's avoiding probate. The other thing to know is that in our world, we really have a lot of predatory marriages. And so sometimes when we say we're leaving it all to the spouse, we're potentially leaving it all to the spouse that leaves the spouse more vulnerable than it otherwise would, or the children vulnerable, right? It's very, very likely that the surviving spouse will get remarried. And so some clients want to build in remarriage protections and that they can be utilized under a trust. Sometimes they want to build in those protections to make sure that if surviving spouse gets remarried and maybe now has stepchildren, another spouse, that their children that they had together don't just get left out. And there's a lot of predatory marriages where you will see specifically the undue influence and really kind of sometimes that manipulation, right? Especially with aging, that can take place and children get disinherited, and that wasn't what they wanted. Or the other rate is the divorce rate is about a 50% factor. And so if the surviving spouse gets divorced, people also usually want to protect what they had built together so that it doesn't get lost in that divorce. And then as mentioned, will is only a death document. It does absolutely nothing for you during your lifetime. And most people don't go straight from dead, right? Living to dead. Most people go from living to having health issues to then dying. So it's important to make sure you're getting the lifetime help. So whereas a lot of times people think about dying, you also have to think about living. It is critical that everyone has, if you're age 18 or older, a healthcare power of attorney and a durable financial power of attorney, a HIPAA authorization. So those are kind of your lifetime documents that, again, it's really important that you have those documents in place. That is what's going to keep you out of what's called a living probate, the guardianship and conservatorship. So make sure that you have them in place. And then of course, on all of these documents, you want to make sure that you have a backup. So if you have just your spouse named as your healthcare power of attorney, that's not good enough because you guys could be in an accident together. Make sure that you also have a backup on each, and then make sure that you're picking the right people. Financial powers of attorney are ripe for abuse. You need to make sure that you're not just choosing a child because they're the oldest. Choose a child because they're the best at financial management. Or maybe you have someone on the healthcare side. So you really need to make sure not only do you have these documents in place, but you have the right people named in the documents, and then also know when they're triggered. So a will is a death document. A personal representative doesn't get appointed until a person passes away, versus the powers of attorney. Those are lifetime documents. At time of death, they become null and void automatically. So when someone passes away, you can't take a power of attorney to a bank and say, hey, I got to write out a funeral expense. You will need to go through that probate process if that probate's triggered. So it's really important to know when they're triggered. Healthcare powers of attorney are a springing power. They will only spring into effect if you can't make healthcare decisions, right? Lack of capacity. And on the other side is the financial power of attorney. With the financial power of attorney, you get to decide when that's effective. Was it effective when you signed it right away? Because you can do that. You can have a springing power. It becomes effective. It springs into effect if you no longer have capacity. And then you can also have a hybrid with financial powers of attorney. Maybe as to spouse, it's effective right away, but as to anyone else, it's only if you're incapacitated. So it's really important that you look at your documents that you have. Number one, have these documents. Number two, know what you have in there, because it impacts your care and your life, your finances, right? So make sure that you have that. And then don't forget kids. We're kind of looking at getting back to school here, right? A whole new class going to school minds. Know that if you are the age of 18 or older, right? You are a legal independent person. Parental rights essentially stop at the age of 18. So it's really important that if you do have any kids going off to school who are 18 or older, we actually would recommend having powers of attorney for them in place. They can have a much more simplified healthcare power of attorney and financial power of attorney. But then as parents, you're able to help, kids. We do see once in a while where spring break, there's a accident, right? And then parents have no legal authority to be able to help. Versus if as a parent, you had a power of attorney for children who are 18 or older, then you can legally step in and know what's going on the healthcare side, be able to help them on the financial, the legal side. Although we call it a financial power of attorney, it encompasses legal matters, tax matters, financial matters, assets. So all of that's covered under that financial power of attorney. So it's really important to make sure you have. So don't forget the kids, if they're 18 or older, they should actually have lifetime documents, the powers of attorney as well. And then we also want to make sure that you know that you're going to walk away from this webinar knowing the difference between a will and a living will, or a last will and testament and a living will, right? So living wills are advanced medical directives. So it has nothing to do with your assets. It is really a directive that says if these events are triggered, go ahead and pull the plug, right? So it should probably be called more of a death will than a living will, but I didn't name them. So a living will is a medical advance directive, basically allowing removal of healthcare treatment, versus a will, a last will and testament. That's going to be that death document that gives the instructions as far as who gets appointed as personal representative or executor and who gets your things. So please know the difference, and then make sure that you're having the appropriate documents in place to meet your goals. All right. Next mistake is not having a trust in place. Now, not everyone needs a trust, but actually a lot of people really do need trust and can benefit from having a trust. So I always tell people, think of a trust like a bucket. So in this bucket, right, you're going to have that bucket in place and you have assets in your individual name. In order for that trust to work, eventually your assets will need to be put into that trust bucket. And so if they're owned by the trust bucket or get placed in the trust bucket, that trust bucket controls how they're managed, how assets are distributed. So it's a really great feature to making sure you or loved ones are taken care of. So there's different types of trust to know about. The living trust or inter vivos trust, that's a trust. A lot of times you might hear it called a revocable living trust too. That's a trust that exists while you're alive. It is an entity that is set up and exists while you're alive, and then it survives death. And then it kind of takes the place of a will as far as giving the death instructions. You can also have the revocable versus irrevocable trust. With a revocable trust, what that means is that you can revoke that trust at any time as the grantor, the trust creator. An irrevocable trust is going to have really strict provisions on how that administration works, but specifically, you will no longer be able to, if you set it up and you're the grantor, you just can't simply revoke it anytime you want to. Most states allow an irrevocable trust to be revoked only if all the beneficiaries of that trust and the grantors sign off and agree to revoke it. So there are going to be restrictions on it. With an irrevocable trust, think of that as, again, that bucket, but this bucket's going to have a lid on top. So you put assets in that irrevocable trust, it's got a lid on top. And so you can't just grab into your trust bucket anytime you want to. So there's restrictions on it. And then you can also have a testamentary trust. And I did mention that not everyone needs a trust, but a lot of people do need a trust. And it might not be a living trust where it's in existence today. A testamentary trust is a trust that you have under a will. This is very common for young families. So if you have young children, a testamentary trust is a great way to make sure that if something happens to you, that then it doesn't just go outright to the kids when they turn 18, right, or go under a guardianship and conservatorship, but instead it goes into a trust. Oftentimes you might see ages like 25, 30, and 35, where then it gets distributed out, can be used for health, education, maintenance, and support. But that trust then is there and it's triggered if basically children need to be helped yet, whether it's financially or because of another issue, even like special needs. So even if a family is young, I would say even more so if a family is young, it's even more important that you have that testamentary trust to make sure children are taken care of. So that is found under a will though, versus the inter vivos trust, which is while you're alive. There's a lot of benefits for having a trust. As mentioned before, it avoids probate. So that's a wonderful thing about a trust. It's going to make it easier for the family. You're going to have less costs and expenses, and it keeps it private. Trusts are private. And there's lifetime benefits with a revocable or irrevocable trust where you will benefit during your life. And then obviously there's benefits for the beneficiaries once you're gone. One of the biggest benefits, I think, is even for a surviving spouse, those trusts can make it a lot easier for them. And then for the children, especially too, it can make it a lot easier. Now, when it comes to the testamentary trusts, those can also provide some asset protection planning for kids. So we want to make sure too that you're titling beneficiaries. So say you have a life insurance policy, make sure on that life insurance policy, your testamentary trust that you have under your will is named as the beneficiary. Do not name the kids. Do not name, Aunt Sally, who's going to take care of the kids. You want to make sure that it's going into the trust. Because if you were in a car accident and you were at fault and now you're being sued, we want to make sure that life insurance proceeds pours directly into their trust, not to your estate where it's subject to creditors and claims. So this will help make sure that it stays protected for the kids. And then we also don't want to name Aunt Sally because Aunt Sally could get a divorce or get in a car accident and be sued, and then the money's lost for the kids. So it's really make sure that you've got the beneficiaries going to the testamentary trust if you have that testamentary trust. All right, next mistake is not coordinating assets. It is not good enough just to have documents in place. Wonderful first step, but in order to get that finish line, you got to make sure that your assets are actually connected with your estate plan. And we see this as a really big, significant problem that disrupts estate plans. People think that they have everything, all of their intentions taken place, but then their assets aren't coordinated. So that's something that after this webinar, I'm going to give you homework. Go through and make sure that whatever your estate plan is, or maybe you're under the government's estate plan, right? The intestacy laws, then I'd encourage you to get an estate plan in place. But go through and make sure your assets are connected, right? Are coordinated with whatever estate plan you do have in place. So if you have a trust in place while you're alive, right, like a revocable trust or an irrevocable trust, you need to make sure that it is in fact funded. What funded means is that if you look at the name of the owner of that asset, so say you have a checking account. If you look at that checking account, who is listed as the owner? It is going to be considered funded, owned by the trust, if the trust is named as the owner. So if you are named as the owner, as the individual, then it's not funded. It's not in your trust. And that could trigger a probate. Maybe you have it going somewhere else. That can cause a lot of issues with your estate plan. Oftentimes we might see a home get funded in a trust, but then no one ever follows up on the bank accounts or an investment account. So make sure that you double check who is listed as the owner. If you have a trust, the trust should be the owner. There's a couple exceptions, but otherwise trust should be the owner. Don't forget property in other states. One of the big benefits of a trust too is if you have property in another state. So say you're in Rapid City, and then you also have property in Wyoming, in the neighboring state. Well, if you don't move property in Wyoming into your trust, then you're going to trigger a probate in Wyoming. So if you have property in more than one state, it's especially beneficial because each state that you have assets in, right, real estate or personal property assets over a threshold, you actually have to go through probate in each state that gets triggered. So make sure that if you have property in other states that you're moving under that trust, and then also make sure designations are coordinated. So if you want it to go to the trust as a beneficiary, you just put the trust in as that beneficiary. Because a lot of times you might see provisions built out for the family under a trust. So you want it to go into that trust. If it's not going into the trust, just make sure that it has beneficiary designations, because we don't want assets stuck in your name at time of death if one of the goals is to avoid that probate. On the designation side, make sure that you've got qualified retirement accounts and everyday vehicles in your name. You do not put any qualified retirement account in a trust. So this is a big no-no. You're going to be giving Uncle Sam a huge tip if you do this. Qualified retirement accounts must be in an individual's name. A qualified retirement account cannot be owned jointly. So you can't own a qualified retirement account with your spouse as a joint owner. You also can't own a qualified retirement account in an entity or in a trust. If you do move it into an entity or a trust, right, you actually speed up all of the income tax burden and have to pay income taxes on it. So qualified retirement accounts are a great way for tax deferment, right? You can defer the taxes on it until you withdraw on it on the income side. You will lose this if you put it in a trust. So never, ever, ever have one of your qualified retirement accounts owned by a trust. Now you can have a trust be the beneficiary. So if someone inherits a retirement account, you can roll that into a trust. But if you are the actual owner, don't ever put it in a trust unless you want to give Uncle Sam a tip. So what I mean by qualified retirement accounts, anything that's tax deferred on the retirement side, IRA, 401k, 403b, KEO plan, anything that's been tax deferred on the retirement side, you don't want to put that into a trust while you're alive. And then everyday vehicles. We don't recommend putting the everyday vehicles that you drive into a trust for optics. And that is because if you are in a car accident and get sued, the last thing we want is that darn personal injury attorney to know right away about your trust. They're going to think, oh, you got deep pockets, and they're not going to be reasonable with settling. They do not know what trusts are for, how trusts are used. They just think that, oh, you got deep pockets, and they don't want to be reasonable with settling. So for that reason, for optics, we don't want them to know about the trust right away off the bat. Now, a number of states have where you can essentially put beneficiary designations, transfer and death designations on a vehicle title. If your state allows that, that's a great way to make sure that there's no loose end of where does the vehicle go, or potentially triggering a probate in that state. So that's something to also consider. And then if you do have an irrevocable trust, those are the buckets with the lid on top. You can't just get your hands in that bucket anytime you want to. So you want to be very selective on what you put in there. But whatever is not in that irrevocable trust, then make sure that it's either in a revocable trust or it has a beneficiary designation, transfer and death, or payable and death designation, so that your intentions are followed and you're not going through intestacy or probate laws. Mistake number 5 is ignoring the digital assets. So in today's digital world, we all have emails, there's Facebook, banking online. There is so much that we do that is digital anymore. And this is really important to make sure that you are not ignoring planning for your digital assets. So on the legal side, make sure that your powers of attorney, right, have the legal capability so that if you become incapacitated or disabled, right, that someone can step in your shoes and legally manage. And likewise, if you have a trust or a will, those powers on the legal side should be embedded in that trust or will to make sure that they legally can handle it. Now, there's the practical side, and that is knowing usernames, passwords, where to find the usernames and passwords, because if something happens suddenly, so say a car accident or a health issue strikes, it's really hard even for spouses to know what their spouse has for digital assets, usernames or passwords. So it makes their life a lot easier by having this organized and then know where to find it, right? So this is something that is important for making it easier on loved ones. Again, it can be a heartache for people, even though there are some provisions in there that if someone passes away, they have different rules to follow. It is still a lot of hoops to jump through, very difficult to navigate, and often people aren't successful in navigating those rules. One example is we had a father pass away, and the son who was in high school kept getting, Facebook reminders of his birthday and other things that are going on, right? Because that is still active in his account. And it was incredibly difficult for that family to try to get access to his Facebook account. So just not putting the family under that, I think, is really important. The other side of it too is knowing that there is a lot of fraud that takes place when a person passes away. We have had Gmail accounts hacked before, after a person passes away. People are trolling to find, who's passed on, death records, all of that. And for whatever reason, we are seeing an ever increase in this area. So to protect from fraud, even, it's really important to make sure loved ones have that practical access to be able to manage and then protect and safeguard, right, those digital assets. We don't recommend sharing that information as far as, giving out your usernames and passwords. Keep that close to the vest, but let people know where they can find that information for you. Even spouses, as mentioned. So if there is a car accident, make sure that the spouse knows where you keep this list. I always recommend keep this list with your estate planning document so that it's all together for people to find. And then probably the one that gets neglected the most is the keep it updated, because we're constantly, asked to update passwords. We're adding new digital assets. So make sure that you're keeping that list updated as well. All right, so next mistake is failing to protect assets. So I know this was called, the 7 estate planning mistakes to avoid, but I'm going to talk about asset protection planning, because if you do not protect assets, then you could have an estate plan that there's no estate to govern over, right? So this is really important to make sure that you are doing asset protection planning. To make sure that you've got that, your loved ones taken care of. So a couple things. Insurance is going to be the first line of defense. So there's the legal protections, but there's the insurance side as well. And there's lots of just different insurance out there, right? So I'd always encourage anyone to look at, if you're working, make sure you have that disability insurance. If you are worried about long-term care, know about long-term care insurance, although less people are doing that just because of the inflation rate on long-term care costs. But then you can do life insurance with a long-term care rider. So just be educated about those different insurances and make sure that you're making smart decisions. On the asset protection planning side as well, what we want to make sure is that you're adequately insured on the liability side. Now, you want insurance to be a losing proposition. You do not want to use this, right? God willing, you don't have to, but it's something that it's important to have because it can just take one thing to go wrong that blows everything up. Now, liability insurance is expensive, so you want to be adequately insured. So make sure that you've got a good insurance agent on your team, right? Make sure that you're asking questions and that they're giving you good answers for how it works, because insurance is expensive, especially liability insurance. So you don't want to be overly insured, but you need to be adequately insured in today's world. The thing that you want to make sure that you have is an umbrella policy. So with the umbrella policies, that basically covers above what the liability. So you can usually get, a couple million for just a few $100s a year of coverage. So compared to liability, umbrella is really dirt cheap. This is also why we see it not sold as much as other insurances, because there's not as much kickback and benefit, right, to that insurance agent, understandably. But from an asset protection standpoint, this is something that I would say do as homework. Figure out if you have an umbrella, right, an umbrella policy, figure out what you have and make sure it's a good amount. So for instance, here in South Dakota, we have very conservative juries and judges. We aren't going to go crazy on an award. Now, you just travel a little bit more, east of us and you go to the, Minneapolis area, their jury and judicial decisions are going to look different. Those are going to be much higher verdicts. So you have to realize too, if you're traveling in other areas or you live in other areas, that you have higher exposure, especially from being on the roads. That umbrella policy is really important. But it's also important to know that if you got a dog and that dog bites someone, you got a teenager, that teenager says some mean words on social media, now you're getting sued. All of those things, that's where that umbrella comes in. So make sure you've got an umbrella policy and then make sure you know your coverage. And then the other thing that you should check with that umbrella policy is whether it has UIM and coverage. So underinsured motorist coverage and uninsured motorist coverage. Now, before, a lot of umbrella policies were covering this. So we are seeing that weaned off because insurance companies, right, they understand that risk is there. And so there's less and less that are covering that UIM and coverage. But if you have an umbrella policy that covers that, that's fantastic. To be quite frank, for instance, with our clients, we are less concerned about them causing a car accident versus them getting hit by someone who is uninsured or underinsured. That is a much greater risk for our clientele that we work with. So having that umbrella with that UIM and coverage is really important. So for instance, if you're carting around other people, maybe you got friends with, or you've got children and their friends are with, right? It doesn't take much to get to $1 million in medical damages alone. And then you tack on other, pain, suffering, all that, loss of income. So having that coverage is really important. And I'd say visit with your insurance agent. They should be the expert that's helping you with that. And then the life insurance side, make sure that if you need that life insurance to make sure loved ones are taken care of, make sure you've got that in place. Because, I've never met with a family that was like, dang, they had too much life insurance. Usually what happens is we'll meet with someone, they're like, we wish we had more because maybe the spouse doesn't want to go back to work after she just lost her husband. Or maybe the children are young and they're worried about making sure they're stretching the dollars now to get them through a certain age. So again, it's really important. You should have a good team helping you and supporting you, not someone just selling you stuff, right? So, go through and just make sure that the loved ones you have are going to be taken care of as needed. And if you need to make any updates, there's no time like the present. On the legal side, what we want you to know about are, for protections, retirement trusts are one of the things that we're using more and more, just because retirement accounts are one of the biggest assets people now have. And a lot of times we might see where they want to make sure that the spouse is the beneficiary, and then it passes on to the kids after the spouse is gone. A retirement trust can ensure that happens. This is used a lot, especially with blended families. Maybe the surviving spouse, they want to make sure they're taken care of, but then at the end of the day, when that spouse passes on, it goes to their children and not spouse's children. So retirement trusts are good options at making sure the retirement accounts can stay protected and used and passed on like people want. Then we also have family trusts. As mentioned earlier, there's predatory marriages out there that some people get concerned about. And so family trusts are a great way to make sure that you can build in remarriage protection provisions. So in case the surviving spouse does get remarried, maybe you're requiring a prenuptial agreement, or maybe you're saying income only. There's different provisions on that family side to make sure spouse is taken care of, but also children are being safeguarded. Family trusts are used less and less because of estate taxes. We'll talk about taxes later, but that also potentially can be a benefit of a family trust to protect assets, protecting from IRS as well. Inheritance protection trusts are probably the biggest thing that people are doing nowadays. The old way of estate planning was you're going to put your children down, and then it's going to go to children, outright, as long as they're over a certain age. Well, once assets go, the inheritance goes to a child and it's titled in their name, then anything that the child's name goes through, such as they get a divorce, they get in a car accident, maybe they have business disruption, they have a health issue hit, right? The number one reason for bankruptcy in America is health related. So all of these things that could happen, rather than just saying it's going to go outright to a child, now more and more people are saying it's going to go into a trust for that child. So if you have more than one child, each child has their own trust. Each child can be their own trustee. Each child can be their own beneficiary. So they can control, manage, and have access to the trust. Now, if you want to govern from the grave, you absolutely can do that. But you can also just give them the complete freedom and flexibility, but know that you've wrapped it in a layer of asset protection planning for them. These trusts do have to be designed correctly, but it's kind of the modern way to leave assets to children, because divorce rate's really high, health risk is really high, right? Bad things can happen to good people. And that's what you're protecting from, usually with the inheritance protection trust. Also, the other greatest risk, right, is that long-term care need right now. So if you're 65 or older, there is a 70% chance of needing long-term care, and long-term care costs are going to vary by state. But each state, it's going to be pretty darn high. So there's just no way around this. Long-term care nursing home costs are usually financially catastrophic for most people. So if you want to be proactive, you can use things like a Medicaid asset protection trust to protect assets. So this is something that's becoming more and more popular, just because of how devastating those long-term care costs can be, and it just keeps getting more and more expensive. With the Medicaid Asset Protection Trust, to protect assets, you do want to make sure that you're setting that up 5 years in advance. Each state does have different rules. For instance, California, very different laws on a lot of different things. And so the same is with their Medi-Cal is what it's called there. But for a lot of the states in America, it is going to be a 5-year look back period. Most states will have some sort of look back period, so know what your state is. But again, general rule would be the 5-year look back period. We're setting those up in advance to be able to be protected for purposes of nursing home protection. And with that nursing home protection, that doesn't mean that you don't have to pay the nursing home. It just gives you that flexibility that the government can't look at as an available resource and tell you just to spend it down. A lot of times our clients might have Medicaid pay the base rate, and then the family uses that money in that trust bucket to pay the difference to be in a private room, so that mom or dad can be in a private room. But now instead of paying, $11,000 a month, they're only paying $2,000 or $3,000 a month, which is a lot, which they can weather that, right? So if there's any, heartburn, I would say, about long-term care costs, think about that, plan ahead, and know that there's tools and asset protection trusts available to make sure that you're protecting your nest egg. For those that, a health crisis hits, we have, under the elder law world, the capability to do crisis planning. We do not need 5 years. We are able to speed up Medicaid eligibility and protect assets. Essentially, if there's a spouse, we can essentially protect about 100% of the assets for that spouse, the well spouse still at home. If there's no well spouse, so it's an individual, then typically you're looking at about 50 to 60% of the assets that still can be protected. But that's really important because we do see health issues strike. If it's early onset Alzheimer's or a stroke, things can happen. And so what we want to make sure that is that there's options to make sure that you aren't feeling overwhelmed with what would happen on the cost side and weathering that, tough situation financially. So that's in the elder law world known as crisis planning for that type of asset protection planning. And then some people will say, well, I'm going to title things in kids' names, and we just want you to watch out doing that. So if you're doing that for nursing home protection, typically that is not a very good idea, because usually there are some tax ramifications that you're going to incur because of that. And then also it's titled in your child's name. So that's, carries a lot of risk as well. Sometimes we also see where a parent might put a child or children on their checking account. They put them on as the joint owner just in case something happens. They don't want that account to freeze and the children have access right away. Again, if you are putting your child on, whether as a joint owner with you, or you're putting a child on as the owner thinking you're going to protect it, you have great risk in that if something happens to a child, then your asset is going to go through that risk, right? So if a child goes through divorce, now your asset is going to be part of that divorce. If a child's in a car accident, right, and gets sued, all of those things. So it's actually more risky than a lot of people think to put a child's name on an asset with them. So just be very cautious if you are doing that for asset protection planning purposes, but also it's usually not the best way for the estate planning purposes either. So we say be cautious when doing that. All right, and mistake number 7 is not having review of your documents, your plan, and updating. This is something that people think it's kind of one and done. Well, now usually it is. Quite frankly, a lot of our clients, right, they do their estate plan and they don't make updates. But that doesn't mean you shouldn't review it to make sure that it's not needed for updates. So make sure you don't commit this big mistake. Because this one happens. Things in life don't stay stagnant. And a lot of times you need to make sure that you're doing those updates. So on the personal side, if you have anything that changes on the family side, if you move to another state, if there's asset holdings that really change significantly, or if you have a health issue strike. And this is the one where I would say we see oftentimes that gets neglected, where they don't come in to do a review of their plan or make sure their documents are in good shape. Because if a health issue strikes, the very first thing people want to do is ostrich planning. Bury their head in the sand because they're going through a hard time, they're scared, and they don't want to think about that stuff, which is totally reasonable. But on our side, right, this is usually the most critical time to make sure things are going to work like needed. So don't do ostrich planning. Make sure that you're getting in and getting your plans reviewed, documents reviewed. And the other side of it, so those are all your personal reasons, but the law changes. And so it's really important to make sure that you're staying current with the legal changes. Right now in America, only 0.1% of the population has to worry about an estate tax. So this year is 12.92 million per person on the estate tax exemption. So 99.9% of us do not have to worry about filing an estate tax or having an estate tax occurrence. Gift tax, likewise, this year it's $17,000 per person that you'd be able to give without having to file a gift tax return. Because the estate tax exemption is so high, a lot of estate plans that if they were done a long time ago can now be simplified to make it easier. So if it's been a long time, blow off the dust, because you could actually make it easier for your spouse or family or loved ones by simplifying. Because if the estate tax is no longer an issue, which for most of us it isn't anymore, then you can simplify your estate plan. The other thing is plan ahead. So the current tax act sunsets in 2025. So that means January 1st of 2026, the current tax act will sunset back, and it's going to now be $5 million indexed for inflation. So each person will have a $5 million index for inflation estate tax exemption. So it literally cuts in half. So if you add up like your life insurance policy, your home, your retirement, all your assets, and that's going to be potentially over, you might want to really pay attention to what Congress does. It's likely maybe they change the law. If they don't do anything, it automatically sunsets. So keep that on your radar. The other thing, just know that the Secure Act in place, and then here this last year, we just had Secure 2.0 get through. This really has changed retirement accounts. So a lot of times people might now be sprinkling those retirement to spread out the income tax burden on beneficiaries. The other one to know is charities. So if you leave retirement to an individual, they're going to have to pay income taxes on it. If you leave that retirement or some of that retirement, right? Maybe it's just a small portion of it, but then the charities get that tax-free. They don't have to pay the income taxes on it. So it's wise to leave after-tax dollars, right? Non-retirement assets to maybe loved ones, individuals, and have the charitable intents coming from the retirement accounts, because the charity gets that tax-free. So the only one missing out is the IRS on that piece of the pie. So, and a lot of times children might be in a higher income tax bracket. So the bigger bang for the buck is oftentimes looking at that charity provision. And if you do have any questions with regard to School Minds, I would really encourage you to visit with Leah. I think she put her name, her email address in the chat box so that it's available. But visit with her about options, because again, a lot of times the only one missing out then is Uncle Sam, and you can benefit your family, and those near and dear to you on the charitable side too. And then obviously asset protection laws are changing all the time. So that being said, those are really what we see for the biggest mistakes. I hope you got something. But if you didn't get something out of this, at least I do know I sent you off with some homework, double check some things, because you do want to make sure you're taken care of. People work way too hard to just leave it to chance, and to make sure that you're leaving money on the table that should be going to your loved ones or to you. So make sure that you're doing this, because you really want to make sure that you're taking care of yourself and your loved ones appropriately. And then last but not least, I'm just going to say, if you haven't been to the School Minds, if you haven't been to their website recently, I would encourage you to check that out. I was just on there to prepare for this presentation, and was blown away with their website, all that's going on. And it's hard to sometimes see how great that is, but super proud to be from the School Minds and just associated with this great alumni group. So thank you for having me. Appreciate it, and would be happy to take any questions. I know I've talked long though, so sorry about that.
We do have some questions, Bobbi, and I'm going to let Leah ask them of you. But I did want to say something real quick for everybody. As you can see, Bobbi has a lot of great information for you. And last year she did a lunch and learn with us that's called the Nuts and Bolts of Estate Assessment Protection Planning, that kind of goes over some other maybe not quite pitfalls, but considerations. And so I highly encourage you to go to our CARA YouTube channel. We will also be sharing that in a follow-up email to all of you. But with that, I will give you back to Leah to ask and answer questions.
Okay, we have a few questions here, Bobbi. We'll get to as many as we can. Is a life estate and transfer on death deed same thing?
So a life estate interest is going to be different than a transfer on death deed. With a life estate interest, you are reserving an interest in that property, that real estate, for your lifetime. And then at time of death, it will go to the remainder beneficiaries. So that is another potential way to pass on real estate. And then you just have to be careful because depending on your state laws, there's different implications, for instance, with predators and Medicaid. But oftentimes that does build in that automatic transfer as well to the remainder beneficiaries, but it guarantees you certain rights in that property while you're alive.
Okay, thank you. Is there financial guidelines for when a trust is advisable versus not advisable?
That's a really good question. I think it really depends more on the circumstances. So a lot of times we'll be doing trusts, maybe for a widow, for instance, who has a home, a bank account, and maybe an investment account, and that's really it. So not heavy on the asset value, but she potentially has issues with lack of mobility, concerns about incapacity, and wanting to make sure that that's managed appropriately for her. So having that revocable living trust while she's, alive, to make sure she's the beneficiary, or even an asset protection trust to make sure that she's got those assets, or at least the value of the assets available for her down the road. So sometimes even the less you have makes it actually more important because that's your lifeline to make sure that you're taken care of. So it's really more about the circumstances than necessarily the asset value. Now, if you have very minimal assets, then typically a trust is not the way to go. But that's pretty minimal anymore in today's world.
Okay, thank you. Maybe we have time for one more. Does your umbrella policy need to cover the total amount of your assets?
I would visit with your insurance agent regarding your exposure. So for instance, especially some graduates that are just starting off, maybe they've got more debt than assets, right? But you have to know that if you're in a car accident, for example, they can collect over, potentially decades. And so it's not necessarily what you have now, but it could be your future earning as well that you're trying to protect. So visit with your insurance agent on the insurance side to be really educated what meets with your specific circumstances.
Okay, thank you. I unfortunately, I think we're out of time. We have a few more questions, but maybe we'll be able to I can ask them to you and maybe send them out via email or something. So Shelley, we'll turn it back to you.
I appreciate that. And yes, we will be sending out a follow-up email for everyone who registered and made it today and everyone who wasn't able to make it today, and we will try to include those. But I do want to say a big thank you to Bobbi. Bobbi, this has been so informative, and you've done it in just the best way that even I understood everything you were talking about, and this is not my background. So I really appreciate your time, and also for your love of the school. And I agree with her. Hop on our school webpage and see all of our amazing things that our students are doing and our alumni are doing, because we love to brag about you all. Thank you all for attending, and I hope to see you at next month's Lunch and Learn, where Dr. Rankin talks about the state of the university. Have a great day. Thank you all.